All right, good afternoon, everybody. I want to say thank you to Kim and the Icons team for making it possible for me to travel halfway around the world to state the obvious. But I do want to start by saying I've had a few people come up to me and ask if I'm all right. I think some of you here would have seen what happened last year, and I do want to reassure everyone that my experience in advocating for women's sex-based rights has galvanised me, and I have no intention of backing down. So even when I was a candidate in the Australian federal election, a political neophyte, I became the most reported on candidate, second only to the sitting Prime Minister. And despite the best efforts of my detractors to discredit and intimidate me into silence, they scored a massive own goal. Gender identity ideology is now in the Australian public discourse, and the critiques are now being ventilated. Unfortunately, though, gender identity ideology is still in the zeitgeist in Australia. We had Zali Steggall, my political opponent, and the first Australian to win an Olympic medal at the Winter Olympics. She called parents transphobic for who had concerns about their daughter's sport. We have the Premier of the state of Victoria who raised the trans flag above Parliament in response to the Let Women Speak rally, where we had young men dressed in black cosplaying as neo-Nazis who showed up to derail our rally. And in defiance of public sentiment, we have sports bureaucrats introducing transgender elite policies that is contrary to pretty much everyone else, saying that if men keep their testosterone to 2.5 nanomoles for 2 years, they are entitled to compete in elite sport. So when I hear Christiana speak, I'm like, we've got a bit of a ways to go in Australia. But in Australia, we have a saying, this doesn't pass the pub test. Meaning, if you ask an ordinary Aussie down the pub their opinion on a particular issue, they would say they don't agree with it or they don't believe in it. Men intruding into women's sport certainly does not pass the pub test. A collision of rights has arisen between biological females recognised as a distinct sex class in law and biological males who wish to identify into that sex class. And the extent to which these interests conflict, sex must have primacy. Because the moment we abrogate sex rights in favour of gender identity, then we deny the basis of human existence. And in international law, which is the scope of my discussion here today, women have sex-based rights that are predicated on having a female physiology, not some simulacrum of feminine appearance or any fantastical legal fiction that allows a male to be recognised as a female in law or a mere utterance or declaration. So in 1979, the UN adopted CEDAW, the Convention for the Elimination of All Forms of Discrimination Against Women. It's a beautifully drafted instrument, and back then, when men were men and women were women, and this wasn't a problem. But women were granted explicit rights, protections and entitlements to eliminate sex-based discrimination, with discrimination described as any distinction, exclusion or restriction made on the basis of sex. The purpose was to achieve human rights equality between women and men, focusing on women's legal and civil rights, particularly in terms of human reproduction. 189 countries are presently signatories and have ratified. The United States and the nation of Palau, while signatories have not ratified, and non-signatories include the Holy See, who has a grand total of about 30 female residents, Iran, Somalia, Sudan and Tonga. In Australia, we thought it was so important we actually even enshrined it in our Sex Discrimination Act in 1984. All signatory states are committed to take appropriate measures, including legislation, to ensure the full development and advancement of the rights of women and extends to many aspects of life, including sport. So sport is not expressly protected as a fundamental in international law as a universal human right. Veronica Ivey, are you listening? There is no specific legal right to sport, and certainly no one has the right to compete in sport wherever, with whomever, and in whatever category they desire. But under CEDAW, women have the right to the same sporting opportunities that men have, whether at a community or elite level. So I know a lot of the discussion is around elite sport, but as we know, community feeds elite, and this is where 99% of sport is actually played. So here we have Article 10G. This is, and the declaration is right there, and also 14C, which describes the rights that women have to access sport on an equal basis. So denying natal males eligibility to compete in female sports is not a human right. It's not a human rights violation. These men are not being denied opportunities, nor are they being discriminated against. They are being treated comparatively to other males. They are not being excluded from sports. They are eligible to play in the male category or any open or mixed categories. Granting males the right to compete in female sports is unequivocally incompatible with this right. When men can avail themselves of that right, its purpose is completely subverted. So CEDAW is one of 9 core instruments that create the international framework for human rights and equality law. The civil, political, economic, social, familial and cultural rights protected under these instruments are universal, inalienable, indivisible and interdependent. All these rights are equal in importance and none can be enjoyed without the others. Responsibility is on signatory nation states to respect and protect and fulfil these rights. And these 9 instruments refer to sex multiple times. They refer to mothers, to maternity, females, pregnancy and lactation, and thus strongly reinforce not just the legal notion, but the incontrovertible truth that female physiology is basal to women's human rights. But despite this, there's a relentless campaign to repudiate sex in favour of gender identity. But unlike women's rights, gender identity is not expressly protected in international human rights instruments. It is not explicitly recognised in international law, and it has no explicit treaty protection. But its proponents argue that when protected characteristics are listed in human rights instruments, so for example, you'll have race, religion, culture, etc., sometimes it says other status, and they try to argue that gender identity falls into other status. However, this is arguable because there is no consensus on gender identity within the cohort of United Nations member states. Only 10% of these nations allow some legal form of gender identity recognition. So the conflict of rights is far from settled. Reem Al-Salem, who is the Special Rapporteur for Violence Against Women and Girls, she speaks to the legitimate concerns of women when she asserts the harm done to women by gender identity ideology. She was highly critical of Scotland's proposed gender recognition law, which would allow unrestricted self-identification. And we all know how that ended up for Nicola Sturgeon. But contrast that to the United Nations independent expert for sexual orientation and gender identity, Victor Madrigal-Borloz. He shamefully advocates for the removal of sex from law and policy and dismisses those who fight for sex-based rights as hateful. So shout out to LGB Alliance in the UK who stood up to this. So for the moment, the status quo remains. there is no fundamental human right to self-identification on the basis of self-perceived gender identity. And insofar as rights for gender identity exist, states have the right, based on international human rights standards, to include restrictive measures as long as they are for a legitimate aim and a proportionate response to that aim. I would argue that restricting eligibility of female sports categories to natal females for fairness, safety, dignity, privacy for women could certainly be argued to be legitimate and proportionate. But trans activists are nothing if not creative. In 2006, the Aguiar Principles were published. In 2017, a supplement called Aguiar Principles Plus 10 were published as well. But this is a document of demands. It's a demand that primacy be given to people with diverse sexual orientations and gender identities above all others. Above all others? It's a specious document. Its proponents purport it to be a universal guide to human rights and insist it binds with the international legal standards with which all nation states must comply. But it is not. So don't believe them when they say it is. It's not. It is drafted and signed by a group of individuals in their private capacity, lawyers, human rights activists, trans rights activists, including, yes, Victor Madrigal-Borloz, who I mentioned before, and there was also Professor Robert Wintermute, who has now come out and since admitted that women were not consulted, nor was the impact on them considered, and for that he has paid a heavy price, even being at the centre of a mob at McGill University when he went to speak about human rights. So the Aguiar Principles exist for denuding law and policy of sex and gender, including any record of a person's sex or gender. And we can imagine the impact that that will have on data collection, on women's rights, on children's rights, when every space, every service is just a free-for-all. So the impact of these principles on any other group was not considered, which is highly unusual in human rights, where there are usually endless conversations and debate on how to balance the competing sides. These principles have not been negotiated and certainly have not been agreed to by any nation states. There have been multiple unsuccessful attempts to have them ratified through the United Nations as a human rights standard, all of which, I think I might say, have fortunately been rejected by the General Assembly, the Human Rights Council and other bodies. Even an Australian Senate committee said the principles have no legal force, either internationally or within Australia. So proponents of gender identity have attempted to circumvent this wholesale rejection by inserting their aims into non-binding United Nations documents. So in 2009, the principles were relied on to justify a general comment, which was published by the Committee on the Economic, Social and Cultural Rights. This is a non-binding but important and expert pronouncement on covenants. And this specifically stated that gender identity is recognised as a prohibited ground of discrimination. In 2010, CEDAW Committee issued a general recommendation, number 28, again a non-binding guideline that provides ways for states to implement the convention, and it extended the definition of discrimination to include discrimination on the basis of sex and gender. So the quote's up there. Here we see gender acknowledged as sex-based social roles and sex stereotypes that arise from biological differences that disadvantage women on the basis of their female sex as distinct from men. Further, reference is made to gender identity, but only insofar as it again pertains to women as distinct from men. So in 2016, the United Nations Council had a mandate that was introduced for the international expert for SOGI, which has given a position to our friend Victor. So this is for the protection against violence and discrimination based on SOGI. CEDAW's committee, again in 2019, called for the elimination of discrimination against women and girls in sport. You would sound hopeful, but this was actually in response to the Casa Semenya decision and the 2018 International Amateur Athletic Federation's regulations that prevented natal males with differences of sex development from competing in the 400, 800 and 1500 sprints. The resolution is arguably misconceived because a policy that advantages males to the detriment of females is incompatible with CEDAW. Again, with the European Court ruling that just recently happened earlier this month, a group of UN experts, including our friend Victor, was issued in support of the Semenya ruling. But again, the basis is that Semenya is a woman and is a female, that he is just a female with different sex characteristics. And the implication being that it is racist or sexist to say otherwise. And they urge sports organisations to review eligibility for these men to be able to compete in the women's category. And finally, in 2019, the Human Rights Council issued a resolution that purported to affirm women's fundamental human rights. But the resolution, which mentioned sex only 3 times and only in relation to sexuality, made mention of gender 37 times. So I must reiterate that gender identity is not recognised in the core international human rights instruments. It remains highly contested without evidentiary basis or majority consensus. So when a male asserts rights on the basis of gender identity, and even when he claims to be legally female because he has changed his identification documents, it is not the same as him being biologically female. I can't believe I have to say that. But insofar as his rights conflict with the rights of women, biological sex must have primacy. However, gender identity has managed to intrude into some national and state laws in some jurisdictions. In Australia and New Zealand, sex has been displaced by gender identity in federal government sports policies. New Zealand unanimously passed sex self-ID, and it's been passed in a number of Australian states. In Australia, sex self-identification was inserted into our Sex Discrimination Act when gender identity was inserted into that federal law by our first female Prime Minister. She is held up as a feminist icon, but this is one of the last things she did. She completely undermined the right of women to be recognised as a distinct sex class in law. And it's created a conflict between sex and gender identity that is now being litigated in our Australian Federal Court in the case Tickle versus Giggle. Yes, I didn't make that up. I don't think you can make that up. But it is legitimately called Tickle versus Giggle. So these are the facts. We have a natal male who goes by the name of Roxy Tickle. He's altered his sex marker on his birth certificate. He wanted to go onto the Giggle for Girls app. However, the CEO, Sal Grover, saw his onboarding selfie. She identified him out. She removed him from the app. So he tried to take her to the Australian Human Rights Commission to conciliate the dispute. She declined to conciliate, so then it went to the federal court, and that's where we are right now. So Tickle is asserting that he was discriminated against on the basis of his gender identity, and Sal Grover is asserting that women and girls have the right to a female-only space online. And Sal created that space because she was a screenwriter in Los Angeles. She was a victim of what turned into the Me Too movement. She came home and she just wanted to have an online space where women and girls could be without being harassed by men, being sent dick pics, being able to find a flatmate, being able to find a job without that male intrusion. So we are now seeing this case in the federal court. It might possibly run to the High Court because the facts of the case have raised a constitutional question in that we are asserting that gender identity is actually not constitutionally valid. The Sex Discrimination Act in Australia takes its legislative power from the fact that it has enlivened the CEDAW Convention, and because CEDAW does not address, it's silent on gender identity. So the question arises is, where does gender identity get its constitutional validity? So we are hoping that it does go to the High Court, so this question can be resolved once and for all.
Shut up, Sal.
Yeah. So the implication for women's spaces and services in Australia will be profound. Will sex or will gender identity have primacy? The presiding judge said, and I quote, "The difference in the applicant's case and the respondent's case is stark and wholly irreconcilable. One will ultimately be found to be right and the other to be wrong." So women's human rights are inalienable, universal, indivisible and interdependent. Now more than ever, those rights for women are being marauded and abrogated. Women's freedom of association, that is, their right to define who can or cannot participate in female-only sports, is under attack. Women's freedom of expression, that is, their right to discuss their concerns about natal males participating in female-only sports, is under attack. Women's freedom of speech, that is, their heroic refusal to comply with radical ideologues' concerted attempts to control language, is under attack. Women's human rights, our right to self-determination, our right to consent, as was so beautifully articulated by the young women here earlier today, but our right to consent is under attack. Once cherished principles of fairness, privacy, dignity, safety and inclusion for women in sport are being sacrificed to affirm the identities of, let's face it, rather mediocre, if not aged out or overweight male athletes. Women's freedom of thought, freedom of belief and freedom of conscience are all under attack, simply because women will not surrender the truth of biological sex. The corpus of international human rights instruments indefatigably supports female-only sports categories for women and girls. There is no justification for allowing natal males to compete in women's sports. So it's very simple for sports administrators, policymakers, legislators to pass the Australian pub test. All they need to do is repudiate the demands of a loud, dangerous minority, preserve the consensus of the majority and defend the existing sex-based human rights of women and girls. Thank you.